Hello everyone and warm welcome to our Women in Sectional Title webinar. I truly hope that you are thriving in this exciting industry, and my wish for all of you is that you truly benefit and see the value personally and professionally in this on this platform. Really hope so. And I just wanted to take a moment to say thank you so very much to our sponsors, We Connect You and Sectional Title Solutions. These companies distinguish themselves in the property arena, and we are really proud and privileged that every month they sponsor us so that we can pop up at 11 o'clock to share information and to give you everything that you need to work in a better way in our industry. So we've got a lot on the go towards the second half of the year. Hopefully, you know, on the 30th and 31st is the Paddocks Summit. That's an online summit, and I think it's going to be fantastic. I'm speaking on the 31st on a panel about international law and how it relates to our sectional title law here. So please do join. We're also looking at NAMA coming to the fore. The National Association of Managing Agents is unpacking the Community Schemes Ombud Service directives, and that will be in-person events. So it will be in Cape Town on the 28th of August, in Johannesburg and Bloemfontein on the 10th of October. 17th of October, they're going to Durban, and on the 15th of November, they will be in Pretoria. So do make sure that you enroll for those. If you need to find out registration details for any of these events, please don't hesitate to send us an email. Right, so today we are going to be dealing with, let me share the screen. Hold on, we need to share the screen. Okay, we're going to be dealing with behind the ruling, what recent CSOS awards reveal. So what I can say to you is that I've been busy with the CSOS trying to get some awards which are relevant and which we have ruled on in now this year, 2025. And the CSOS have drawn a couple of lines in the sand. So before we go into these rulings, I picked 7 of them, but it's very important to know that in terms of the CSOS directive of 2020, we have a situation where adjudications would only be conducted by the papers. So you don't have in-person rulings anymore. It's only on the papers. Now, from my perspective, and you know, I can say this, it might not be the feeling of women in sectional title per se, but I really believe that in-person hearings carry some sort of advantage over only hearing things on paper. So we'll see what happens going in future. But I think from COVID days, it was just a lot easier to do it. You can also obviously file your submissions and your annexures and everything, but it's all in writing. So if I'm an adjudicator, I will have everything in front of me. I'll read it all, and that's it. I make my ruling. Secondly, from an evidentiary point of view, we need to look at how CSOS works as an adjudication platform. So this is not a criminal law hearing, where your test is that it's beyond reasonable doubt that the adjudicator must be happy with the applicant's submissions. But it's all relevant evidence is taken into consideration, only relevant evidence, and then the adjudicator must weigh up that evidence on a balance of probabilities. So what is the probable cause, and is it probable that the circumstances have transpired which give rise to a certain adjudication award? I'm also going to tell you how long it's taken for these adjudication awards. I think it's interesting. People always say, how long does it take for CSOS to give a ruling? So these are just random adjudication awards. And lastly, before we start, I must tell you that the CSOS seems to be taking into account internal remedies very seriously. In the awards, I've noticed that they say what internal remedies were sought before it came to the CSOS. And there we look at the CSOS or the adjudicators in the CSOS obviously being mandated to make an adverse inference against those applicants where they haven't tried to internally remediate the matter. Okay, so having said that, let's get stuck in. I'm sure you're quite interested to see. The first one we've got here, Samira Ibrahim, the Terraces Body Corporate. The date of the adjudication here was the 27th of January. Well, the order that came out, 2025. It's interesting to note that on the 25th of July, 2024, this matter was sent for adjudication. So it took 6 months to adjudicate. And here we have an adjudication. This body corporate is in Century City in Cape Town. So let's go through the background. The owner of Unit 203 at the Terraces lodged a complaint about damage to her vehicle caused by tree sap and berries falling from the trees in the complex. She requested the removal of the tree, compensation for vehicle damage, and a more convenient parking bay. The key issues that were raised by the applicant: the tree sap and berries caused damage to her vehicle, so she was going to seek financial compensation for that. She was worried about the alleged inaction and dismissiveness by the managing agent. She requested the removal of the tree in her application, a carport installation, or the reassignment of a parking bay. And she wanted the CSOS to investigate the body corporate's conduct in this matter, and obviously, again, financial compensation for all the hassle that she went through here. Okay. The respondent's defense, the body corporate's defense here, was that the removal or relocation of the trees was deemed to be financially and aesthetically impractical. The carport installation and parking bay reassignment requires unanimous owner approval. The reason they said that was because they were looking at the management rules, the management rules to change the exclusive use areas because it was in their management rules, or else to actually register in an exclusive use area notarially. So that's why they talk about unanimous approval. The body corporate offered regular tree trimming and a new parking bay without surrounding trees. The body corporate emphasized fairness to all 144 owners and not just this particular lady. So let's see what the adjudication award said here. So the adjudicator in this matter said that the request for tree removal was denied in terms of Section 54(1) of the Community Schemes Service Act. The adjudicator took into consideration the costs and the broader impact that they may have. Something to note here, when you advising clients to go to the Community Scheme Ombud Service, if they're asking for your advice in any way, you need to know that in my experience, adjudicators don't like to give removal orders for trees and anything from a gardening point of view, because people go, up in arms unless there's a huge amount of damage being caused and it cannot be ameliorated. So in this position, regular trimming of the trees was ordered within 14 days. What about the compensation for vehicle damage? Well, we know that this is not a place where you can ask for civil claims and that you can hold people civilly liable for things. And again, so many of my clients come and they say, well, the CSOS just didn't grant me my award, or the CSOS are useless because they didn't take into account what I said. It's because you need to carefully craft CSOS applications. More and more CSOS adjudication awards are being chucked out because people are not understanding what they're asking for. So compensation for the vehicle damage was denied in terms of Section 54(1) of the CSOS Act. And the adjudicator did highlight that CSOS lacked jurisdiction over civil liabilities claims as held in Prague in Own Another versus trustees for the time being of the Mitchell's Plain Industrial Enterprises. This case is the locus classicus, the model example case where they say you're not allowed civil liability claims. And then, of course, the request for CSOS to investigate the conduct of the body corporate was denied because that doesn't fall within your Section 39 of the CSOS Act anyway. So that everybody says look into them and hit them on the knuckles, and we want all of these kind of we want to be vindicated, and often people don't get what they want. A takeaway from this case, because I've read through all these awards, is that the applicant said if the managing agent had been a little bit more understanding and a little bit more forthcoming, instead of fobbing them off, they wouldn't have taken the matter to adjudication. Okay. Yeah, I know. I can see all the managing agencies here. Like, we have time for all of this, right? Okay. Let's look into the next one. So Samuel Mukundi, and that's Musanan Gurwa versus Parkview Body Corporate. Parkview Heights Body Corporate. The date of the adjudication when it came out here was on the 11th of June, 2025. A Durbanville Western Cape matter. We see that this adjudication was handed over on the 8th of April, 2025. So it took 2 months. This was a quick one. Okay, the background here is that the applicant challenged fines and warnings issued by the body corporate for alleged noise disturbance and disruptive behavior. He claimed procedural unfairness and a lack of evidence. The key issues raised by the applicant. So he said that fines of 500 Rand and 750 Rand were issued for noise disturbance in September 2022. There were prior warnings in August 2022 for loud music and alleged drunken behavior. He said that in the evidence, nobody had brought forward evidence that he had been drunk. There were no blood tests. The respondents, by the way, had said that this loud music was from sort of 12 o'clock midnight to 3 a.m. in the morning. The applicant argued that the fines were issued without due process or progressive escalation. The applicant claimed that the incidents were exaggerated or misinterpreted, and there was an alleged lack of direct complaints or opportunity to respond. The respondent's defense here provided a timeline of warnings and fines from August 2022 to March 2023. And I must say, those warnings were comprehensive. They cited ongoing complaints from residents about noise, aggression, intoxication, and parking violations. They asserted that internal remedies were exhausted and requested CSOS intervention. They emphasized the duty to maintain peaceful living conditions. Okay, so the adjudication order here. The adjudicator noted that in terms of Section 13(1)(e) of the Sectional Title Schemes Management Act 8 of 2011, an owner must not use his or her section or exclusive use area or permit it to be used in a manner or for a purpose which may cause nuisance to any occupier of a section. Now, that is used all the way through these awards. You'll see this come up, especially if it's a behavior-related matter. The adjudicator noted that the applicant had been issued with multiple fines and warnings by the respondent over an extended period, which was supported by several emails from residents complaining about the applicant's disruptive behavior. Procedural fairness concerns were noted, but were outweighed by the seriousness and recurrence of the disruptive conduct of the applicant. Additionally, there was no evidence provided by the applicant to prove procedural violation or invalidated fines. The application was deemed misconceived and dismissed in terms of Section 53 of the CSOS Act. I wasn't personally involved with this matter. It does worry me to the extent that we always tell people that when you put fines and penalties into your conduct rules, that you do need to have the right to be heard. So there's the warning, and it's a directive from the CSOS as well, where you need to give a warning, then you need first transgression, second transgression, etc., before the fine is imposed. Also, that person needs to be able to come to a hearing or to some sort of meeting with the trustees to be heard. And in this matter, I think that, I'm not sure, again, I didn't see all the evidence, but this might have been a very different case if this had landed on my desk, because I value the right to be heard. It's part of the sort of legal tenets of your constitutional rights. So not sure, flying a little bit close to the sun this way. Okay, then we've got the Tavistock Body Corporate and Steve Derbler. And here you've got the date of adjudication. The date it came out was the 27th of May, 2025. And it was sent to adjudication on the 7th of August, 2024. So here we have a 9-month waiting period, and I think it's, I mean, I disagree with this waiting period, because I think when this adjudication came out, things had been sorted out in any case. This was in Morningside, Durban. So the applicant representing Tavistock Scheme Body Corporate alleged that the former managing agent, Stephen Derbler, failed to hand over key scheme records after his tenure ended on the 31st of March 2024. The key issues raised by the applicant: despite multiple requests, the respondent did not provide the required documents. The applicant requested access to 27 categories of records, including financial reports, owner and tenant details, meeting minutes, insurance and tax documents, CSOS registration and levy rolls. I mean, there's a lot of information that you need when you're changing hands, and most of the managing agents, portfolio managers understand this. The respondent's defense was that he confirmed that he wanted to comply with all of this, but he claimed that there were logistical challenges. He said that, and I'll read from the award, all records in hard copy and handing over originals would leave them without proof for their own records. He said they are unable to retrieve stamped bank statements due to loss of access to the APSA account. The respondent explains logistical challenges in compiling 5 years' worth of documents, cites operational difficulties during their tenure, and requested the trustees formally list the documents they require. And they reaffirmed their intention to comply and to commit to doing so once a clear list was received. Okay, so the adjudication order, let's go and look at that. The adjudicator made reference, and this is important, note it down, prescribed Management Rule 27.7, which definitively states that if the body corporate terminates its contract with an employee or a managing agent, that person must, within 10 days, deliver to the body corporate all records referred to in this rule that are in the person's possession or under the person's control. In light of the above, the adjudicator ordered that the respondent was legally obligated to return the documentation to the applicant within 10 days of cancellation of the agreement. And they gave that, in the award, if you look at it, they gave them 2 months to comply, not 10 days. So they gave this Steve Derbler till the 31st of July to comply. So, I mean, it's all a bit of a nonsense, if you ask me, because at the end of the day, I mean, you know, this should have been heard urgently because you need those documents. It's a quick thing. So to wait all these months and then to give another 2 months, I don't know. I'm not loving that. Right, let's go on. Now, this is a hornet's nest, this one. Raj Maharaj and Pravda Investments and others. Raj Maharaj had a big problem with Matthew Pravda, who was an attorney. Both of them had been trustees, and Raj, I think, had been the chairman of this body corporate. The date of the adjudication was 7th of June when it came out, 2025. It had been sent to adjudication on the 4th of February, 2025, so 4 months. Not too bad. And this was regarding the Lighthouse Body Corporate in Umhlanga Ridge in Durban. Okay, so the background here. The applicant lodged a complaint seeking a declaration, so a declaratory order, that renovations and signage by Pravda Investments were unlawful and should be removed, as well as a finding that one of the trustees acted contrary to the Sectional Title Schemes Management Act and prescribed rules. So it should be noted in this matter that Raj Maharaj didn't only take the unit owner, Pravda Investments, and another to the Ombud. They also took Lightstone Body Corporate as a second respondent, and they also took the chairman of the body corporate on. So those were the 3 people that were cited. Raj also asked for an attorney-client costs order against all 3. So the key issues raised, and this was a core complaint, was unauthorized renovations and signage on common property. I remember reading that these renovations was an 18 square meter deck and air conditioning that had been placed outside the unit. Quite a big thing to demolish. And the signage was a sign to say that they were attorneys. So it was Pravda and Noel's attorneys. It was a sign outside the office. This was an office space. Also misconduct and irregular expenditure by one of the trustees, breaches of governance, including improper proxy handling and AGM irregularities, alleged complicity by the managing agents, requests for CSOS to intervene, and rectify governance failures. So many applicants think that CSOS has a magic wand and they're going to just wave the magic wand and sort out all their problems. Again, in my experience, and a takeaway for CSOS awards is that less is more. Don't go to CSOS with 100 complaints, because somewhere in that wash, something is going to be lost. Rather fight the battles that you're going to win, rather than set out 100 million things that you want the CSOS to look at in one go. The respondent's defense, let's look at it. The respondent's defense, he said, is that all renovations and signage were approved by the body corporate and relevant authorities, being the municipality. And something to note is that before transfer had even started, this Pravda Investments had already started the renovations. And I think that's enough to start getting the backs up of everybody in the complex. The applicant had previously acknowledged approval during his tenure as chairperson. The complaint was described as personal, vexatious, retaliatory, stemming from the applicant's dissatisfaction with AGM outcomes. Don't we all know the story? Sour grapes. The respondents emphasized procedural compliance and good faith actions. Okay, now in the award itself, the conclusion that the adjudicator drew here, another thing we can learn from. The first respondent, so that's in other words, the Pravda, submits that the relief sought by the applicant, which aims to restore the status quo, in other words, to demolish the renovation, would require demolishing a significant part of the building at great cost, as well as vindicatory actions against multiple parties, including the current managing agents and the body corporate. They noted that the applicant appears to act alone without support from other body corporate members, indicating that the matter should actually be dealt with by the High Court rather than by CSOS. The applicant's complaint is vague, poorly structured, confusing. The involvement of the Board of Trustees is unclear with no proper notice. The applicant is described as a knowledgeable, wealthy individual expected to present a clear, transparent case with full disclosure. His failure to do so undermines his credibility and reliability. Despite being assisted by an attorney, he has not met the burden of proof required by CSOS rules. What's the burden of proof? Balance of probabilities. The applicant also failed to exhaust internal remedies within the body corporate. I know that in the course of this documentation, it seems that the applicant was just not prepared to talk at all. Not prepared to talk at all. Didn't want to go to meetings, didn't want to meet with anybody, wouldn't even, email, consider any emails. So they're very upset. He's very upset about that, and he carries on and on. Okay, so they want attorney-client costs there. So let's see, the adjudication award. So the adjudicator basically said that he wasn't prepared to order a demolition. Again, very rare that they do order demolitions. He says that Section 21 of the National Building Regulations and Building Standards Act states that a magistrate shall have jurisdiction to make an order prohibiting any person from commencing or proceeding with the erection of any building, authorizing a local authority to demolish such building, if the magistrate is satisfied that such erection is contrary to or does not comply with the provisions of the aforesaid Act. The adjudicator noted that the CSOS does not have the jurisdiction to order demolition. Such relief must be sought through a court of law under the National Building Regulations and Building Standards Act. So the applicant's request for demolition of the renovations and signage was dismissed, as those elements form part of the building. The adjudicator then also highlighted another locus classicus case, which says, that this is the case of the trustees for the time being of the Avenues Body Corporate versus Shmaruhayu and another, the court ordered that adjudicators are only empowered to make decisions in accordance with Section 39 of the CSOS Act. The adjudicator was thus unable to grant an order declaring that the conduct of one of the trustees is in contravention of the Sectional Title Schemes Management Act and the prescribed management rules. Okay, so again, in this adjudication, just like the other ones, there was no order as to costs. So it's almost like each party must sort out their own costs. If you've obtained the services of an attorney to prepare your papers, which most people are doing nowadays, then you would have needed to pay your own costs. There's no cost order. The Ombud wants to stay right out of that unless there's really been gross misconduct by one of the parties in bringing an application. Okay, then we go on to Miramar Body Corporate and Singh and Suknandan. And the date of the adjudication here was the 10th of February. It came out and it was referred to adjudication on the 26th of April 2024. So that took 10 months. 10 months, way too long, way too long. And this complex is in Lagoon Drive, Umhlanga. So let's have a look at the background of this matter. The body corporate sought relief under Section 39(2) of the CSOS Act, requiring 2D, requiring the removal of a pole and a sliding garage door erected by the respondents on common property without written trustee approval. So if I may just draw your attention to how this is how it works in the scheme, is that there are a whole lot of open carports. And people would sort of share, two cars would be parked in one large carport. So what this respondent did here, these respondents, they put a pole in the middle, and then they put in a garage door, like a corrugated iron garage door, going up and down for the one. And this was shared premises. So the key issues that were raised by the applicant, they said that the respondents installed a pole and sliding door in the shared garage without the written consent from the trustees and consent from the co-user of the garage. The installation restricts access and violates several conduct rules. The structure is not in line with the original design and interferes with the shared use. So the respondent's defense, and so many defenses I've heard from respondents, they claim verbal approval from one trustee. Or they say, oh, the chairman said I could do it. There were 5 trustees. So they said Mr. De Wet, a chairman or trustee, and Wilma from unit number 10, some other unit owner, said it was all fine and they can go ahead. Dangerous. The respondents asserted that the installation aligns with the other units. I saw those photos, they definitely didn't. The respondents alleged that the structure benefits both parties and was not objected to by the neighbour. That was also denied. The respondents accused certain trustees of being vindictive and inconsistent in rule enforcement. Okay, let's see what happens here. So the adjudicator said that in terms of prescribed conduct rule 5.1 of the Sectional Title Schemes Management, they said an owner is prohibited from making changes to the external appearance of the section or any exclusive use area allocated to him or her without the trustee's written consent, unless the change is minor and does not detract from the appearance of the section or the common property. Okay, so just to rest here for a moment. It's often quite difficult to distinguish between minor changes and major changes. And minor changes have been held to be things like, I don't know, putting up a nail and a photograph outside your unit, a little picture, or some sort of ornament outside your unit, even an awning, but only an awning of certain proportions, because I've seen huge awnings that have been placed on the outside of units, which certainly don't constitute minor changes. Minor changes are also things that trustees can give consent to, like burglar bars, and in the old days, the old act used to say mosquito nets and, things like that, that are not going to, upset the world but the trustees still need to get involved with. The adjudicator said that in order that written consent from the full board of trustees is required. Well, obviously what it meant is from the majority of the board of trustees is required. Verbal consent from one trustee is insufficient, always insufficient. In addition, the respondents' actions breached the scheme's conduct rules and the Sectional Title Schemes Management Act. The structure interfered with the shared use of common property and was erected without due process. So it's also we're looking at equity. The Community Scheme Ombud Service is a service of equity awards, and they look at the impact that your conduct is having on other people as well. So the respondents in this case were ordered to remove the pole and sliding door and to restore the common property within 30 days. Again, every single adjudication award has to have a time period or a deadline at the end of the award. So this was the deadline. Alternatively, what they said is that the body corporate could do it if within those 30 days the respondent didn't do that, then the respondent didn't do that, then the body corporate could do it and charge the reasonable costs for doing that. And you see, wherever there's specific performance in terms of structure removal or anything like that, these awards will say if the respondents fail to do it, then you can go ahead and do it within X amount of days. Obviously, you would have to make this award a court order in order to do that. Court order in order to do that. Let me just have a look at the chats here. Margot says she agrees with me about having to do things in person. I see that. Let's just see if there's anything else. Okay. Right, let's go now to the next one. On to the next one. This is Ian O'Brien on behalf of Krishna Road Investments Pty Limited, and that was the applicant against the North Coast Road Park Body Corporate. This is an industrial complex in Glenmore in Natal, and this was a situation which looked at remedying the July 2021 civil uprisings. The adjudication came out on the 27th of May 2025 and referred to the Ombud on the 7th of August 2024. Again, this took 9 months to sort out. The background: the applicant sought relief under Section 39(7)(a) of the CSOS Act, claiming that they were wrongfully denied access to financial records and insurance documentation following a 32 million rand insurance payout after the July 2021 civil unrest. The key issues raised by the applicant alleged misuse of funds, including A, demolition and rebuilding of undamaged sections, use of funds for administrative expenses and unauthorized improvements. In fact, the wording in the award, the applicant says that the respondent, the body corporate, the trustees were using this amount that was paid in as their own private slush fund. The applicant claimed that repeated requests over 2 years were ignored. The applicant asserted legal entitlement to access as a scheme member and director of an owning entity. Okay, so the respondent's defense here. The managing agent claimed that the applicant was given access to the bank statement during a visit on the 21st of August 2024. The respondent requested withdrawal of the application to save CSOS resources, and no further submissions were made. Okay, so let's see here what the adjudicator said. Right, adjudicator said, in terms of prescribed management rule 27.5, a body corporate must comply with a request for inspection or copying of records or documents within 10 days. Remember, if you want rules, those rules must be sent within 5 days. So this is a management rule that is definitely utilized all the time in sectional title schemes. In light of the above, the adjudicator highlighted that the body corporate is legally obligated under the Sectional Title Schemes Management Act and prescribed management rules to maintain proper financial records and to provide access thereto to members upon a written request. Verbal claims of access to partial records do not satisfy the full scope of the applicant's request, and thus the applicant's right to access was unlawfully denied. The respondent was ordered to provide the applicant with full access to the following documents: all insurance claims submitted and approved, payment details from the insurers, the allocation and use of the received funds, and the trustee member resolutions regarding the fund use. So this is really a situation where I suppose, the trustee saw a huge amount of money coming in. I think it was probably quite irresponsible of the insurance companies to pay such a huge amount all in one go, and rather to see that the work is being done as it progresses. I'm not sure in your experience, and maybe if the ball was in your court, how you would deal with it as a portfolio manager, and how you deal with requests to view information. I think it's a no-brainer. This fight and up and down, they didn't give me access. The minute you don't give people access to records, they think there's fraud going on. They think there's a problem, and they just get more and more aggressive. So again, advice would be, allow them to come to your offices, make a special time for them that's convenient to you, and have exactly what is necessary laid out for them to have a look at. They're entitled to see the books of account and record. Just one thing on that, though, you do need to make them sign something just to state, an indemnity just to state that they're not going to disseminate this information to anybody else because of the POPI Act. That's quite important. If people come and inspect your books of account and record, have that drawn up. Okay, then we go on to our last one. Yeah, this one again. Two very strong-willed people, two people where there's most certainly a personal issue, and here we are in Roodepoort at the Ramsig Manor Body Corporate, all about WhatsApp groups, all about defamation. The date of this adjudication was the 15th of May, 2025. It was handed over on the 25th of March, 2025, so another good one, 2 months, that's acceptable. Highly emotional matter. So Mr. Dallin Jacobs took Ms. Risha Tulsi on, and the background is that the applicant sought relief under Section 39(2)A of the CSOS Act, alleging that the respondent's behavior constituted a nuisance, including defamatory statements and false statements via email and via WhatsApp, and they set this out in not such great detail, the applicant. Unauthorized photography of the applicant's pet. Never take pictures of people's pets because this, puts them on edge, totally on edge, like towards lunacy. Mr. Jacobs also said there was harassment and manipulation within this community. What he actually requested was that any information and anything pertaining to his name, to his family's name, or to his pet must be removed from all social media within the scheme, and he wanted an order to stop the behavior of Risha Tulsi. The respondent's defense. Now, Risha Tulsi was a lady. She's a lady, and she stated in all her papers that she was terminally ill, and obviously this has caused huge emotional stress. But she's quite a savvy lady because she submitted a comprehensive 76-page rebuttal of all of this. The respondent asserted that the applicant's claims were unsubstantial, lacking evidence or legal merit. The respondent highlighted her terminal illness and the emotional toll, actually, of ongoing harassment. The respondent accused the applicant of misusing CSOS to intimidate residents and to bypass internal dispute resolution procedures. Again, the internal dispute resolution procedures. And the respondent called for trustee governance reform and the dismissal of the application. Okay, now, there's a case which all law students will know, and it's Pillay versus Krishna, 1946 case. It's an appellate division case. And the gist of this case is that the onus of proof rests on he who avers. In other words, on whoever is complaining, the applicant. And that's something that we can take. This is a takeaway from these awards. If you're going to make a complaint to CSOS, it's got to be substantiated, especially on the papers, because it doesn't look very good if you've got a one-page little application and the respondent's got a 76-page rebuttal. You've got to be professional, and you don't need to put 76 pages together, but you do need to have everything in order, professional, and set out, because, you know, that adjudicator's got access to nothing else. He's not going to see your body language. He's not going to see the fact that you're very upset. It's all on the papers. So in this case, let's have a look. The adjudication order says the applicant failed to provide sufficient evidence to prove nuisance or harassment. The adjudicator made reference to Pillay versus Krishna in this regard, whereby the court stated that the onus of proof rests on the party who asserts the claim, in this case, the applicant. CSOS, very importantly, does not have jurisdiction over defamatory claims or requests to remove personal information from a media forum. This is due to the fact that adjudicators are only empowered to make decisions in accordance with Section 39 of the Community Schemes Ombud Service Act. The adjudicator noted in this regard that such an application must be made in court. So if defamation, if there's something to learn from this, anything about defamation is out of your CSOS order, anything about a civil claim is out. Anything about damages, about emotional stress, or about the fact that you've lost a rental or that you've lost something due to the actions of the body corporate is out of the CSOS, out of the realms of CSOS. The dispute did not meet the legal threshold for nuisance under the common law or the CSOS Act. So again, you know, he didn't have anything corroborating from the neighbors. He didn't have anything. He's obviously a man on a mission and a personal vendetta. The application was dismissed. Again, each party to pay their own legal costs. So that's it. Don't overload you too much, hopefully. And I think that that was just specific. If you've got any questions about any of these applications, or you'd like a copy of any of one of these awards, please let me know. To say thank you to all of you. Our digital platform, Women in Sectional Title, please don't go yet. I want to tell you that there are quite interesting things afoot with Women in Sectional Title. As managing agents, you are now able to advertise on our site. We can give you a link for advertising. We can give you a link for our banners. And for Women in Sectional Title posts, you can put on your email signatures to say that you are, you do proudly support Women in Sectional Title. There is an annual fee of 2,500 Rand per year to do this, but you also then get the link for our website, and you can click through from your website to ours, and you can give your clients a little bit of additional value. Obviously, also your staff members can then be on these things for free, and we send them all the links so that they know exactly what is going on. So, yeah, again, just to remind you, Paddock Summit, 30th and 31st of July, and then your NAMA, unpacking the CSOS directives, which I think is really, really important. I think you need to be up to speed with that. So please, I haven't been able to answer questions on the chats. I do apologize, but this has taken us to more or less to the end. Yeah, well, actually, with a minute to go to the end of our webinar. If you want to hear about anything in particular, please make sure that you email me directly, marina@bbmlaw.co.za. Obviously, the book co-authored by Corinne Blaze and myself, Demystifying Sectional Title, is available on our website. Take advantage of that. The book gets delivered to you. And of course, we're accessible at Women in Sectional Title. If you have any issues or problems, or you're worried or concerned, either professional or personal, please reach out to us. That's what we're here for. I chatted to John Wakefield, who's one of our managing agents who has taken us up on this opportunity. And he was saying, that the men in his office also get involved with the Women in Sectional Title webinars and watch the recorded webinars. And we often say we're very open to that. We're open to men who support women. And yeah, on that note, we hope to see you next month. Look after yourselves and take care. And thank you for all the support. Really appreciate it. Bye for now.